In its landmark decision, Roe v. Wade, the U.S. Supreme Court determined that a pregnant woman's right to an abortion is usually protected by the U.S. Constitution. The judgment of Roe v. Wade invalidated a number of federal and state abortion regulations and sparked a national discussion about whether or how much abortion should be permitted, who should make that choice, and what place morality and religion should have in politics. It also influenced discussions on the procedures the Supreme Court ought to follow when making constitutional rulings. Norma McCorvey, who filed the lawsuit under the legal alias Jane Roe, became expecting her third child in 1969. McCorvey needed an abortion, but Texas law prohibited it unless it was absolutely required to preserve the mother's life. Sarah Weddington and Linda Coffey, two of her attorneys, filed a lawsuit on her behalf in a federal court in the United States against Henry Wade, the district attorney in her community, claiming that Texas's abortion laws were unconstitutional. The applicable Texas abortion laws were deemed unconstitutional, following a decision in her favor by a 3-judge panel of the U.S. District Court for the Northern District of Texas. The Supreme Court heard the parties' appeal of this decision. The Due Process Clause of the 14th Amendment to the United States Constitution establishes a basic right to privacy, which safeguards a pregnant woman's right to an abortion, according to a 7-2 decision by the Supreme Court on January 22, 1973. The court further ruled that the right to an abortion is not unqualified and must be weighed against the interests of the state in safeguarding the health of women and unborn children. By announcing a timeline for each pregnancy trimester that will guide all abortion laws in the U.S., the court was able to reconcile these conflicting interests. Governments were only able to mandate that abortions be carried out by licensed medical professionals during the first trimester. Governments may impose restrictions on abortions during the second trimester, but only in order to save the health of the mother, not the fetus. Abortions might be controlled and even outlawed after viability, which encompasses the third trimester and the final weeks of the second trimester, but only if the legislation made exceptions for abortions required to save the mother's life or health. The court further categorized the right to an abortion as fundamental, which required courts to assess contested abortion restrictions using the strictest possible judicial review standards in the United States. One of the most divisive rulings in American history was the Roe decision by the Supreme Court. Some members of the legal community, including those who support abortion rights and believe that Roe arrived at the right conclusion but went about it incorrectly, attacked the judgment and labeled it as a case of judicial activism. Others claim that because Roe was framed in terms of civil rights rather than more general human rights, it did not go far enough. Polls conducted in the 21st century revealed that a majority and a plurality, particularly in the late 2010s to early 2020s, rejected overturning Roe v. Wade. This was in contrast to the anti-abortion politicians and activists who desired to restrict abortion or overturn the judgment. Although Planned Parenthood v. Casey, 1992, overturned Roe's trimester framework and abandoned Roe's strict scrutiny criterion in favor of a more flexible undue burden test, the Supreme Court upheld its central conclusion in that case, notwithstanding criticism of Roe. In Dobbs v. Jackson Women's Health Organization, the Supreme Court overturned Roe on June 24, 2022, on the grounds that the right to an abortion was not deeply rooted in this nation's history or tradition. It was not recognized as a right when the Due Process Clause was ratified in 1868, and it had not previously been recognized in American law until Roe. Many 21st century rights that are taken for granted today, like contraception, interracial marriage, and same-sex marriage, were not in existence when the Due Process Clause was passed in 1868, according to the dissenting opinion, which was challenged by certain legal historians. The anti-abortion and pro-abortion movements in the United States supported and opposed the judgment, respectively, and it was universally denounced by worldwide observers and foreign politicians. Thank you for watching. Please remember to smash the like button and subscribe to our channel to keep updated on our newest content.